Well, thank you so much for the kind introduction. I hope you can all understand me. I'm very sorry that I can't be there in person with you. Last minute, I had a request from EUIPO to present some ongoing research on copyright metadata the very same day today in Alicante. So you see me sitting in an office which EUIPO made available for joining you at least online, which is a pleasure to do, of course. So let me see if I can start the presentation. This one, I think. Can somebody confirm that you can see this presentation on the screen?
Yes.
And is it moving now?
Yes.
Okay, very good. So we are all set, we can start. I'm asking because as has already been mentioned, when you do this presentation, you don't see the audience any longer. So I'm basically speaking against a black wall, so bear with me. AI Act and author remuneration is what we have now seen as a regulatory approach in the AI Act, something that could be a model for other regions. I have been critical about what we had in the directive on copyright in the digital single market already, so it won't come as a surprise, I think, when I say the short answer that I have for you is no. I think the AI Act is not a very promising model. The reason for this is the following. So here is an overview of policy goals and the effects that I would expect based on the AI Act. You see on top, I have listed as a policy goal fair remuneration for authors, which is something that at least in the copyright system, in the copyright debate, is a central topic, of course. But I guess policymakers also look for something else, not only fair remuneration for authors, but also sufficient resources for AI training so that the AI sector can build the best, most competitive, high-quality AI systems. And then you see in the first column where I have listed the results that I would expect for the AI Act, it's all in red. I would say if you follow the opt-out mechanisms that have been established in the Copyright Directive 2019 and now confirmed in the AI Act, it's not sure that this will really lead to remuneration for individual authors. And in any case, what the AI Act says about opt-out is a big burden on AI training. So I guess for building a successful AI sector, the approach in the AI Act is not really promising. I will explain this in a bit more detail, and then if time allows, I will move to an alternative approach. And as you see here in this overview sheet, I guess this alternative approach offers much more potential for realizing both objectives, namely fair remuneration for authors and at the same time sufficient access to training resources at low transaction costs for the AI sector. But we take it step by step. So I stay in the area of the AI Act, and let me explain why I think that the AI Act is not such a good approach. I have three central points of critique. The first is the opt-out approach that has already been developed in the Directive on Copyright in the Digital Single Market, but at the time it was not really focused on AI training because generative AI systems had not been known at that time. I think this opt-out approach is wrong, at least as a regulatory answer to the questions that we now have in the Gen AI area. Second point is, practically speaking, the opt-out mechanism is unlikely to work in practice. So the results that everybody expects, I would say, are unlikely to really materialize. And my third point of critique is that it is also wrong to try in the AI Act to extend EU policy regarding generative AI training to other countries, the so-called Brussels effect. I start with the first of those. The AI Act has confirmed the opt-out approach that has already been known from the Copyright Directive 2019. Why was this an important thing? Well, there was some doubt whether the opt-out mechanism in the Copyright Directive 2019 would also apply to the training of generative AI systems, because after all, these systems had not been known to the legislators and policymakers back in 2019. So the AI Act tackles this issue by saying providers of general purpose AI models should put in place a policy to respect union law on copyright and related rights, in particular to identify and comply with the reservations of rights expressed by rights holders pursuant to Article 4.3 of the Directive on Copyright in the Digital Single Market. So a clear reference to the opt-out mechanism that we know from the 2019 directive. And so at least that's my take on this. This really settles the issue. I don't see much basis for still arguing that the opt-out mechanism is not intended to cover generative AI models. Problems arising from this opt-out approach and the confirmation in the AI Act, well, I've already hinted at this. The opt-out approach is, of course, complicated and burdensome. For AI trainers, it is, of course, quite a challenge to clear all the rights that might be necessary for building a successful AI model. We also see the transparency issue in the enforcement area. There is a whole working group set up now at the AI office to discuss how these lists of training resources that AI companies will have to submit under the AI Act, how this can be implemented in practice, how this could work. I think it's quite clear that with this opt-out approach, we really put a heavy burden on AI training. And I guess this can easily lead to a situation where AI developers, in order to limit the costs, will simply focus on mainstream training resources. So, well, of course, for an AI trainer, it is relatively easy to imagine that it could make sense to knock on the door of Universal Music and Time Warner and other really, really big content owners and enter into negotiations at high industry level. But I think AI trainers are much less likely to make the same effort with regard to niche repertoires, a small little indie label or a small film producer, a company which does not have a large portfolio of works, because in the whole corpus of training materials, these niche repertoires may just not have enough weight to justify the effort of entering into negotiations. So the transaction costs and the issue concerning these costs can easily lead to a situation where in the European Union we get AI systems that are predominantly trained on mainstream content from big content owners, and the niche repertoires, the more independent avant-garde things, may not find its way into the AI models. At the end of the day, it's also a question whether by following this model, we marginalize European cultural expressions. If it turns out that for AI companies, training materials from other regions are easier to find, either because there are no opt-outs in Southeast Asia and China and Australia and UK and who knows, why not using the resources from those countries, which then leads to a situation that European literary and artistic content falling under an opt-out would not become visible in the AI models and also not in AI output. This leads to a broader cultural issue, if that assumption is true. Honestly speaking, about this last point, I don't have empirical evidence yet. I'm not enough of a specialist in AI training methods to now already say that we will face this marginalization issue, but it's conceivable. And that leads to a further issue. I guess in a couple of years, and we see this already starting right now when we look at the use of Gen AI systems by our students or more generally in the literary and artistic field, I guess a mode of production where we take a Gen AI output as a template for what we add as humans, and that, as Christoph has explained, if it's substantial human input, then perhaps even arrive at a human creation that justifies copyright protection. But in any case, the template for the work will very often come from Gen AI systems, which means if we don't have enough European resources in the Gen AI models, then European culture and literature will just not be present there. Another thing here is that from a freedom of expression perspective, and Christophe has explained this very well, of course, we can also say it is from a broader societal perspective, it is important to have generative AI systems that are really capable of empowering citizens to contribute to the literary and artistic discourse. Let me explain that point in a bit more detail. So in the past, in the sense of the analog past before the internet revolution and so on, we had only restricted access to the literary and artistic discourse, which depended heavily on the intermediaries, the distributors like the film producers, the book publishers, or the question what books are finally on the shelves of bookshops and so on. So if as an author you really wanted to reach consumers, you really wanted to reach audiences, you first had to convince several players in the value chain that your book, your film, your music is really worth being developed, exploited, performed, and so on and so forth. This has changed radically with the whole issue of user-generated content, where we had the move from passive consumers to active prosumers, the user-generated content revolution, where via online platforms, suddenly everybody could reach end consumers directly, which already led to, well, quite an important emancipation of the literary and artistic discourse. Discussions in intellectual property law have in particular also been about piracy and infringements and so on and so forth. But after all, user-generated content really has this revolutionary character in the sense of empowering each and every citizen to participate in the discussion concerning literature and art and contribute to that and reaching end consumers directly. And so in a way we can say, and as I said, I mean, this really follows closely the argument that Christophe has also developed. In the world of generative AI systems, everybody can in principle become an artist. We have a further democratization step of the literary and artistic discourse because the result of generative AI prompting are very valid contributions to the discussion. But for this whole emancipation, democratization of the process to take place, you really need well-trained generative AI systems, and for my taste, also generative AI systems that fully reflect European cultural expressions and not just the expressions from other countries or regions where no opt-out system blocks access to this. So this is why I'm quite concerned and also really against this opt-out approach. I would also say at a practical level, the opt-out approach, which has all these costs in terms of freedom of expression, the opt-out approach is unlikely to work. At least it's unlikely to work in favor of individual authors. Why is that? Well, a further consideration from the recitals in the AI Act, namely that the use of works and other subject matter referred to in that paragraph has not been expressly reserved by their right holders in an appropriate manner, such as machine-readable means in the case of content made publicly available online. My excuse, I was wrong in referring to this as an AI Act provision. It's, of course, the opt-out clause in Article 4.3 of the CDSM directive. So what I highlighted here in red are the three magical words that this provision particularly difficult to apply. It's the focus on an opt-out based at the level of individual works. So for individual authors, this leads to several questions. If the opt-out has to be declared in a machine-readable way, the first question is, well, do you have to attach your out really to the work? Do you need some watermarking, fingerprinting, whatever that includes your opt-out? Or is it sufficient that you declare the opt-out on the website? The current debate is very much about robots, text, and websites. So let's say the mainstream approach at the moment is to say an opt-out on the website is sufficient. But then if we accept the website's approach, then you still face the problem then that an opt-out on just one website may perhaps not be enough for the whole internet. So if you are a photographer and you declare an opt-out on your personal homepage, then that's nice. But if your photographs are always also to be found on 10, 12 other platforms on the internet, the question is who carries the burden of making sure that the opt-out is also respected on these 10, 12 other web pages. Is this something which the right holder, so the individual author, has to do, or is this a burden that rests on the AI industry? Like if the AI industry comes across an opt-out on a personal website, the AI industry has, I don't know how they would do this, would have to index all the works on that website, not for the purpose of including it in the training data set, but for checking where on the internet these works are to be found as well, and to exclude it altogether from the AI training data set. So the approach as described in Article 4.3 of the CDSM directive is quite difficult to implement. And it doesn't come as a surprise that AI companies, in a reaction to this, have already started offering so-called opt-out services. OpenAI, for instance, has developed an opt-out tool where, as an author, you can fill in a form and you provide information on the works that you have, and you declare an opt-out, but you also give lots and lots of metadata about your works to the AI company. Which brings me to a further point, and that's the point of metadata hegemony. So whether we like it or not, this whole opt-out model, with all its practical implementation problems, leads to a metadata flow to the AI companies. And this is also a broader trend. It's not the first time that metadata flow to AI companies or tech companies in reaction to copyright legislation in the EU. We see the same effect in the area of content moderation, content filtering in Article 17 of the CDSM directive, which also requires right holders to notify works to online platforms like YouTube in that case. So EU legislation stimulates metadata flows to tech companies like platforms and AI trainers. And this is then, of course, a basis for data hegemony of big tech. Perhaps even a bit more worrisome when we also consider that the same players, platforms and AI trainers, might have quite a large portfolio of personal data available, so they can easily match copyrighted content that is available with individual tastes of consumers who ask for certain copyright protected work. So we deliberately put platforms and AI developers in a very strong position in the metadata field. And I think the time is ripe to discuss countermeasures. One countermeasure would be the development of an integrated EU infrastructure where we bundle all the notifications, all the opt-out declarations that go to platforms and AI trainers, and establish a parallel metadata pool that also gives EU newcomers in the platform and AI area equal chances of competing and also reaping the benefits of these data streams. But that's just a side issue. Let me return to the more practical side of things. Another thing that is unlikely to work with these opt-outs is collecting societies. We see more and more collecting societies declaring a collective opt-out for all the right holders represented by this collecting society. The trend started, I believe, with the French SACEM doing at least one of the first, if not the very first, opt-out collectively for the whole repertoire. And now the question is, are these collecting society opt-outs valid? One question is, do the collecting societies have TDM rights at all? Has a right holder who joined a collecting society back in the 70s or 80s or 90s, when nobody knew about text and data mining and modern forms of developing generative AI systems, can we assume that the reproduction rights that have been given to a collecting society 30, 40 years ago, that this grant of rights would include TDM rights? And then, of course, another question is, again, how do we make the link between the collective opt-out and individual works in the repertoire of collecting societies? Who has to carry the burden of informing the process of AI training? If a collecting society like SACEM, or in my example here on the screen, the Dutch collecting society Pictorite for picture, photography, illustrations, and so on, does the AI developer have to determine which works fall in the portfolio of Pictorite, or does Pictorite have to establish some data interface informing the AI crawler which works fall under this opt-out? So yeah, there are quite a couple of unresolved issues out there. For the time being, I'm not so sure that the collective opt-out will work that well, which is really a pity, because in general, collecting societies seem to be ideally placed for granting umbrella licensing for AI training. Last point in my list of concerns about the approach taken in the AI Act, this is the intended extraterritorial impact of EU copyright policy. Providers that place general purpose AI models on the EU market should ensure compliance with the relevant obligations in this regulation. So the moment you offer a fully trained AI model on the EU market, you have to be able to provide evidence that it has been trained in full compliance with EU Union law on copyright. For this purpose, the providers of these AI models should put in place a policy to respect Union law on copyright and related rights, in particular, and then again, reference to the opt-out mechanism known from the CDSM directive. Quite clearly, the Brussels effect is intended here. The European Union wants to make sure that AI developers do not have advantages just because they did the training in Japan or the US or some other country or region that poses less obstacles and less cost challenges to AI training. But then the question is, of course, how realistic is this? So if you think about an AI system that has been developed in Japan, strictly following the much more generous, I believe, Japanese rules on the issue. And then finally, this AI system is a huge success in Japan, and the provider thinks, okay, as a next step, I bring this to the European market. And then the European Union authorities say, okay, you can offer it here, but you first have to show that you have done the training in compliance with EU policy. Well, if this is a startup company, I believe it will have had other things to consider than training in full compliance with EU policy. So this Japanese provider of perhaps a very powerful AI model faces basically two scenarios. Scenario one, not offering this AI system in the European Union altogether because it has been trained in accordance with Japanese rules. So if an AI trainer, in my assumption, is unlikely to observe the EU restrictions when training models in other regions, then we would say, well, the result is that we see less AI models being offered in the EU, or models in the EU being less powerful than models being trained more broadly outside the EU. So we get different worlds here with European Union citizens and users in general being disadvantaged, I would say, because the EU AI systems will not be as powerful as the systems in other regions. And then a final point here is sustainability issue. If the EU now tries to advertise this approach and other countries and regions follow and establish their very individual rules on AI training, we end up in a situation where instead of just training one AI model, we would have to train different versions of that model, depending on what training materials can be used for the development purpose. And that's, of course, from a sustainability perspective, that would be a catastrophe. If instead of training just one model and then using that model as a basis for providing AI services, you would have to train 100, 150, I don't know, different versions of the model to make sure that the models comply with the individual copyright rules in all different countries and regions. We get into a situation where the whole AI training process and updating process would really become quite a heavy burden on the planet. I heard yesterday on the news, I don't know whether this was on the news in your countries as well, but at least here in Spain it was on the news, that companies involved in AI training in the US are asking for more nuclear power plants, 6 additional nuclear power plants that would be necessary to feed all the AI systems that are currently developed. So there seems to be a sustainability issue and an impact on the environment that goes beyond at least what I had imagined before. But from that perspective, a piecemeal approach where each and every country does its own thing and imposes this policy on the training of AI in other regions is just a very problematic practice. So enough concerns. There is light at the end of the tunnel. I have a couple of minutes, I guess, to turn to the green alternative that I have indicated here. I can be short on that one. I have repeated this in a couple of comments and also in some articles. I think, and there I totally agree also with what Christoph has already said with regard to AI training, we should move to general lump sum remuneration systems. A final question then is, okay, should the remuneration be paid at the AI training stage, at the input level, or should the remuneration be paid at the output level when the fully developed AI systems are finally brought to the market? My personal view and advice has been from the very beginning to wait until the AI systems are fully trained, to wait until the fully trained systems are brought to the market, and then we impose a levy. So in a nutshell, I would envision unbridled AI training freedom to get the most powerful, most diverse, least biased AI models and AI systems. And then once these AI models are implemented in AI products and services that are brought to the market, that's where copyright should enter the equation and where we should introduce a levy system. So a mandatory payment for AI products and services capable of substituting human creativity. There should be a statutory AI fee that could be at a relatively high level to make it easier for human creators to compete with AI creation. So we could artificially make AI output more expensive. This AI fee, the levy, should be paid to collecting societies, so mandatory collective management, and then the collecting societies via their rules on social cultural funds, also based on the repartitioning schemes for money they have to distribute, of course, can share the revenue with different groups of authors, also right holders, and they can do this in accordance with their self-determined repartitioning schemes and so on. So, perhaps noteworthy that the Court of Justice in its Amazon judgment concerned private copying has confirmed that collecting societies have quite some freedom in this area for investing in social and cultural funds. So there is room here. And well, that would be my preferred solution. I would say this is a solution that leads, first of all, to a result where we really get fair remuneration, and we make sure this fair remuneration really reaches individual authors via the collecting societies. And at the same time, we can have a successful AI sector in the sense of an AI sector that enjoys broad, unbridled freedom of resources for AI training, and has to pay the levies later on. But at least during the AI training process, we don't put too heavy burdens on the AI developers. The latest update, if you're interested, this is the latest paper on this issue that I have prepared. Also reflects the point of bias and non-discrimination interests, and also literature developments that we see in this discussion. And with that, I would stop here. Thank you so much.